to order and ask the members of the committee to enact your cameras. And I would ask Attorney Del Campo to call the roll to see if we can identify how many of the members are with us.
Okay. Justice McDonald is here. Judge Chaplin.
Here.
Judge Farley.
Here.
Judge Hernandez. Judge McLaughlin.
Here.
Judge Nguyen O'Dowd.
Here.
Judge Pearson.
Here.
Judge Prats.
Here.
Judge Stewart.
Here.
Thank you. That's it, Your Honor.
Thank you very much. The first item on our agenda then is the 2022 minutes approval for the November 14th, 2022 meeting. Is there a motion to approve the minutes?
Motion to approve, Judge Prats.
Thank you. Is there a second?
Second, Judge Pearson.
Thank you. Did anybody identify any changes or modifications that are required to the minutes, including Attorney Del Campo?
No, Your Honor, I did not.
If there are no changes or amendments, is there a motion? Is there a, how about we do it this way? All in favor, raise your hand. Opposed? That passes unanimously. The next item on our agenda is 2022-011, proposal to amend the practice book to eliminate the requirement for original printed deposition transcripts to permit service of civil complaints by consent. Attorney Del Campo, could you bring us up to speed on the new material?
Yes, Your Honor.
Joe, I'm sorry to interrupt. It looks like Judge Prats has her hand up.
I think she was voting on the minutes.
You're muted, Your Honor.
How do I undo the hand?
You click it again.
Okay. Is that good?
Should have gone down. No, it didn't go down.
Yeah.
There you go.
There it is.
Okay, thank you. Sorry about that.
No problems. Attorney Del Campo.
Yes, Your Honor. This proposal came in September, was first on the agenda. It was a combined, it was two different proposals from Attorney Goodbaum. The one remaining proposal is this one concerning the transcripts. It was again on the agenda on October 17th. The committee tabled it at that time, asked me to contact the Connecticut Reporters Association, which I did. Ms. Mannix has, the next time it was on the agenda was November 14th, the last meeting. Ms. Mannix, the president of the Connecticut Court Reporters Association, was in attendance and addressed the committee. The committee asked her for some research concerning watermarking the PDFs that would be sent electronically. She has put together some materials which you have in your package today. She was unable to be with us today, so I believe the vice president of that organization is here, Elisa Graziano. If you'd like to ask her questions, she is here today.
Hi, thank you for having me, members of the Rules Committee. I'm Lisa Graziano, the vice president.
Thank you. So I read the letter that we received earlier today. Am I correct in concluding that it does appear to be workable from the perspective of the association?
Yes, Chris, the president, who was not able to be here, she, along with some of the board members, were able to, you'll see in the packet, she did send you an example of how we can mark it. It's in the back of your package.
Okay, are there any questions from members of the committee? Does anybody see any problem with us moving forward with this? It seems like it's workable, but I'll open it up for discussion.
I think it would be fine. I've just sort of lost track. Do we actually have proposed language anywhere? I tend to think we don't.
I thought Attorney Goodbaum had given us that.
Well, he was
That's what-
advocating to basically get rid of the whole requirement.
Oh,
Um,
Wait
which
a minute.
it doesn't sound like that's the direction we're headed in. It would just be that we would replace the old, paper transcript that said original on the front page that was in a sealed envelope with a PDF with the watermark on it.
you are correct. I thought we had the language in front of us.
If I may, I think the proposal just requested removing the word original from the language in the practice book.
You know what? Why don't we do this? I'd rather have something written that's actually before us. It helps the flow of paperwork. It helps our staff keep track of it and keep us on point. So I'm going to ask that we push this over for a month and allow our staff an opportunity to get us actual formal language for the modification of the practice book so that we have it in front of us. Does that sound okay with everyone? Okay.
Yeah.
Attorney Del Campo, is that okay with you and your folks?
Yes, Your Honor, we'll prepare something. Thank you.
Thank you. Thank you very much.
Thank you.
Thank you. I appreciate your time. The next item is 2022-015, a proposal to amend practice book section 7-19 to make it clear that judge may conduct an ex parte review, I believe, of the applications that we were talking about, and I believe we have agreement from Judge Albus. Well, why don't I just ask Attorney Del Campo to bring us up to speed?
Yes, Your Honor. This was originally proposed by Judge Bellis. It went to the Rules Committee working group. Judge Farley, Judge Stewart, Judge Pearson put together a revised draft, sent it to Judge Bellis, and then you did consider it once, or actually the working group came back to the committee, asked if it could be sent to Judge Albus, and it was, and Judge Albus's comments are in the packet. Judge Farley may want to address it further at this point.
Well, I think we're ready to move on it. So under the existing rule, this application for subpoena process was done ex parte. One of the concerns Judge Bellis raised was that sometimes information is conveyed to the court in that context that really ought to be shared with all parties. And so that's one thing that this revised rule does, is even if it's dealt with on an ex parte basis, the application can be made a part of the record. And the other thing that we've done is to, where time allows, to allow a judge to deal with this on the record completely. That is, file the application, allow objections, and make a ruling. And we've preserved the rights of those who are subpoenaed to move to quash or move for protective order as appropriate. So I think that's what we've done.
Okay, I just want to make sure we're all on the same page. We are talking about what's titled Revision B, which is identified as 2022-015C. Is that correct?
Right.
Okay. I just want to make sure everybody's on the same page. Are there any questions, most likely for Judge Farley, from members of the committee? If not, is there a motion to approve this item?
I'll move it.
It has been moved. Is there a second?
Second.
Is there any discussion? Seeing none, all in favor, please just raise your hands. Opposed? That passes unanimously.
Your Honor, just one comment, if I might.
Yes.
This proposal does not yet have a commentary. You've passed it, that's fine. I guess it can go to a public hearing. We will bring back a commentary for the committee to consider next meeting, if that's okay.
Yeah, yes, it is okay. We don't. I forget me. I should remember this. Do we vote on the commentary? Don't we?
Yes. Well, the commentaries are Rules Committee commentaries. Yes, they're published with the proposals. They actually go in the practice book as Rules Committee commentaries, not as judge adopted commentaries. But you will need one before it it gets proposed for adoption. So I'm neglected to get that to you, I suspect.
No
earlier,
problems.
But,
We'll do that in 2 steps then. We'll vote on the commentary separately.
all right, thank you.
Thank you. All right, so the next item is 2022-017, a proposal to adopt a new rule regarding the transfer of in-camera records from the FOIC to the trial court in administrative appeals. We have some new material, and I believe Judge Cordani is also joining us. I appreciate him making the time. Do we have Colleen Murphy? And Colleen is here. Attorney Murphy, if you could turn on your camera.
Yes, I'm trying right now. Let's see. There we go.
There you go. Thank you.
Thank you.
Okay. So, Attorney Murphy, have you seen the responses of the responses from Judge Cordani and court operations been shared with you, or no?
I inquired about them just about an hour before the meeting. I hadn't realized that there were remarks, so I did inquire and received them, like I said, within the hour. So I've done a quick review of everything, but there's a little more than I anticipated. So I'm not sure I'm fully prepared to respond, but
well, they are of course public documents, so it's only appropriate that the executive director of the commission have them. Do you want more time to review them before we try to engage in this discussion?
I think that would be helpful if I might just make one remark at this time and maybe amplify it later, if that's all right with you, Judge McDonald.
Sure.
I think on a quick read that there to some degree is a misconception about what we're trying to do here, particularly with the remarks from the representatives from court operations. Certainly, we do not want to be viewed as going against the spirit of open government. I think that might be the first time that we've been on the receiving end of that, and it doesn't feel good. So I'd really like to, yes, have the opportunity to amplify that a little bit, perhaps at the next meeting.
So what I was going to recommend is, rather than us just wait, is if I could recommend that you sit down with the folks from court operations, and if Judge Cordani is interested, including him in the conversation, so that you can have some meaningful discussions before our next meeting, so that we're not just losing time and picking up where we are right now in a month from now.
Sure, I'd be happy to do that, and I'd really love to have Judge Cordani be part of that if he were willing and able.
Yeah, sure. I would be very happy to do it, of course.
Appreciate that, Judge. And I would also recommend that Attorney Del Campo or someone from his staff participate in it as well, so that we can be brought up to speed about it before next meeting. Okay?
Yes, sir. Yes, sir. Thank you.
Anything further on that at this time? All right. Both Judge Cordani and Attorney Murphy, I appreciate you attending the meeting today.
Very good. Thank you, Judge McDonald.
Thank you. The next item is 2022-019, proposal for various rules changes related to the Connecticut Bar Examining Committee's new online application process. Attorney Del Campo?
Yes, Your Honor. This was on last meeting. It was put over to and referred to the Connecticut Bar Association. I just received comments from the Connecticut Bar Association at 1:29 before the meeting. So you don't have those as yet, but Attorney Biggs, on behalf of the Bar Association, did indicate that the CBA has not received any concerns about the proposal and has no additional comments at this time. So they have no concerns with the proposal.
Were they I can't remember, were they the only people we circulated the proposal to?
Yes, Your Honor.
Okay.
Yeah.
Kathleen, would you like to address us at all on this item?
Good afternoon, Your Honor. Thank you. I'm Kathy Harrington, Deputy Director of Attorney Services. As we discussed last time, the Bar Examining Committee has contracted with ILG to do an entire online application process and applicant portal. We've gone live for the February 2023 bar application process, and hopefully in the next few weeks we'll go live with the rest of the applications. So most of these rule changes that we're proposing would help effectuate that change. Since we're no longer going to be paper-based, we will be online. For example, no longer filing of affidavits. Since we won't have paper documents, there'll be certifications that attorneys in other states and employers will be certifying to the bar examining committee. There was also one other rule change that the committee noted for 2-8, which went kind of beyond the new applicant portal issue, which was taking out the intent requirement for someone who does not meet the educational requirements set forth to sit for the bar exam. The reason why that is being presented is we had a similar intent provision in the motion rule for people who are motioning in from other states. A few years ago, that was taken out of the rule, and we noted that this there was still an intent requirement under this provision. We have no other intent requirements under any other rule, so the committee voted to present it to the Rules Committee for your consideration, whether you would like to take it out or leave it in. I know that some of the rule changes, for example, like the authorized house counsel rule, there's a lot of lines struck through, but really the substance remains the same. We just reorganized the rule and reworded it so that it would not be submission of these documents in affidavit or paper form, but rather certification to the committee. Attorney Valco is also on the line. She is the director of Bar Examining Committee. We're both available to answer any specific questions that anyone may have. Thank you.
Thank you. Are there any questions from members of the committee to either Kathy or Lisa? Attorney Del Campo, did you have anything that you wanted to say on this item or no?
No, I did not, Your Honor.
Okay. Does anybody see any problem with us moving forward then on a motion to approve this item? If not, I will accept a motion to approve.
So moved, Judge Pearson.
Thank you, and I'm going to take that as a second from Judge Prats.
Yes.
Thank you. Is there any discussion? Hearing no discussion, all in favor, please raise your hands. Opposed? That passes unanimously. Thank you to both Kathy and Lisa for your time and attention on this matter.
Thank you so much, and happy holidays to everybody. Thank you.
You too. The next item is 2022-020, a proposal to amend practice book section 17-51 to permit the entry of a summary judgment based on a defense, and that defense only affects part of the claim. This is a first time being before the committee by a member of the committee. So I'm going to ask Judge Stewart if she'd like to address the item.
All right, so I'm going to assume, which is always dangerous, that you all have read my cover letter that sets forth the rationale. I bring this up because I have at least twice now run into this in a case where someone has moved, typically on the statute of limitations, but I've seen case law involving other defenses, and they ran into a wall. Current wording of section 1751, which does address summary judgment on part of a claim, but the way in which it's written presently suggests that I know that it dates from the era when you could only get summary judgment based on a complaint or a counterclaim or a cross claim. And there used to be, for those of us who have been around a while, you would go to short calendar, and if you tried to move for summary judgment on a defense, you would just lose on the grounds that it wasn't provided for in the practice book. And I believe it was 2013. Anyway, some years ago, this committee revised the 1744, the basic summary judgment rule, summary based on a defense, but for whatever reason, at that same time, they didn't address section 1751, which addresses part of the claim. The only other thing is I am not, no pride of authorship in my proposed language. I recognize that the way that rule is written right now invites probably some other changes, but I tried to just stick with my knitting and just propose language address my concern, and I thought that the easiest way to do it was to split it into two subsections. Subsection A, addressing with the scenario of where the moving party is someone who has filed a complaint, a cross complaint, or a counterclaim, and is affirmatively trying to get summary judgment in their favor on a claim. And I kept the two scenarios where part of the claim is admitted, or part of the claim would survive a special defense. And then my second portion of the rule, subsection B, I wrote as if the proponent of the summary judgment motion was trying to get summary judgment in their favor on a defense, where that did not entirely bar the claim. So that's my introduction. I'm happy to entertain questions or comments.
I'll open it up to members of the committee. Anything in first blush that you wanted to address? We do need to populate this to the Bar Association, to the trial lawyers, the defense lawyers, and to Judge Bellis, and maybe Judge Alvis. Would it apply to family? You're muted. Oh, there you go. No, you're on.
You know, I mean, I sat in family for over 2 years, and I can't recall a single motion for summary judgment. But I will defer to some of the people on this call who've been in family longer than I have, with whether that's a common
but it
occurrence.
doesn't mean it doesn't happen.
Right.
Okay, why don't we then? Is there any suggestions other than the Bar Association, trial lawyers, defense lawyers, and Judge Bellis that we should ask for comments for this item? Taking silence as acquiescence. I will ask Attorney Del Campo to solicit input from those four, and hopefully we'll have their commentary back. The only thing I wanted to ask Judge Stewart is, and I know you're picking it up from existing language, but I frankly probably have never read the rule that closely. What does it mean to say on such terms as may be just?
I don't know. Yeah, the language of the rule, and I should know this. I did look at it. I can't remember when it was last or if it was ever revised. Doesn't really fit with the rest of the summary judgment rules, to be honest with you. So I left that alone, but I just don't know what they were driving at.
Okay, well, if we're going to be changing it, we should probably make it for the better then, and address that item. And so I'll ask Judge Prats in a second, but one of the things I was thinking is that maybe Attorney Del Campo or somebody on his team could chase down the origins of where that came from, that just language. And maybe we can be edified about why it's appropriate to have it in the rule as amended, if we're going to amend it. Judge Prats?
Yes, in terms of whom it should be disseminated to, does that include legal aid? Because I know they handle a fair amount of housing or evictions and things like that.
It's a very good suggestion. Yes, we will do that to the various legal aid organizations.
Okay. Thank you.
Anything more?
And
Well,
Judge Farley?
If now we're critiquing the rule as it exists, I wonder whether the word final adds anything to the rule, or whether it just might create confusion for people who might bring their case to Justice McDonald prematurely.
Yeah,
Are you suggesting our jurisprudence on final judgments is not crystal clear?
When I see final, I worry people might get the wrong idea.
Yeah, I mean, that's what I alluded to earlier, that there are some, this rule, in my opinion, I tried to address my principal concern. It doesn't mesh others. I mean, the other summary judgment rules do not say final judgment. That's one example. Another thing is the way in which this is written. I mean, really, when you're granting or denying summary, you're deciding whether or not there's disputed issues of material fact. Anyway, the way the rule is currently written, it's sort of But I decided, all right, I just want to queue up my issue, which is at the moment, it's pretty darn hard if you're a defendant to actually get a partial summary judgment on your, special defense. Because of this rule, the way it's written, but it's not well written.
I'll say from my perspective, anything that says final judgment for so much of the claim as the defense does not apply, doesn't sound like a final judgment.
Right.
So,
It should
so,
be summary judgment.
Yeah, why don't we ask Attorney Del Campo to see if there's any inherent wisdom in having that language remain the same, or whether we should change that as well.
Yes, Your Honor. I'll do that.
Thank you. Anything further? If not, we'll pass that item for the moment. And I believe that's actually the end of a relatively short holiday season agenda for the committee. Is there anything else that we need to be taking up? If not, I will accept a motion to adjourn and wish everybody a happy and healthy holiday season. Is there a motion to adjourn?
So moved, Judge Prats.
Is there a second?
Second.
All in favor, please raise your hand. Opposed? That passes unanimously. Have a good one, everyone.
Happy holidays.
Take care.
Thank you.
Happy
Thanks, you
holidays.
too. Thanks.